Hello, everyone. Good morning. Also from our side, wonderful to see so many of you here. A very warm welcome from us. That is basically those who are on stage and also RexAI. So my name is Philipp. I hold the chair for Law and Ethics of the Digital Society at European New School of Digital Studies at European University Viadrina. Basically a small university right outside of Berlin. And I'm absolutely thrilled to be leading today this panel with an absolutely stellar lineup of folks who are going to be talking about international AI regulation, some of the challenges, the bumps in the road, and the perspectives and opportunities ahead. So please welcome with me on stage, first to my right, Miriam Vogel. She's the president and CEO of EqualAI, and she's also the chair of the National AI Advisory Committee to the US President. Many thanks for coming over all the way from the US. Then we have another person from the US, that's Dean Ramayya Krishnan. He is the dean of the Heinz College of Information Systems and Public Policy at Carnegie Mellon University, and also a member of the NIAC. And both of them have recently co-authored, together with the other members of the NIAC, as you might have seen, a very pertaining study on the implementations of the NIST framework on AI in the context of an international safety perspective. So this is something we will talk about today. We then have further members from the policy field. Kai. If you know anything about AI and the AI Act, you of course know Kai. Kai Zenner, he is not only the head of office of Axel Voss, one of the shadow rapporteurs of the AI Act in the European Parliament and the digital advisor there, but he's also, you could say, the architect of foundation model regulation at the EU level. So if you have anything to blame it on him. And if you have any improvements, so we need constructive critique, please, also address it at him or me. Thanks so much for coming, Kai. I know that your agenda is super loaded these days. The AI negotiations have not yet finished, but he will tell us the latest about where we stand on this. And then finally, it's a great pleasure to see Rasmus on stage. Rasmus Rothe, we've known each other for quite some time. In fact, we were neighbors in Berlin, and that's how we met, bumped into one another, actually over fixing the heating. And then we found out that we also have other things in common. And so it's great to see you here. Of course, he's one of the initiators of the AI House, and he's also the founder and CTO of Merantix, one of Europe's leading AI companies. And he was going to give a bit of a business perspective on the question of how and when and if at all, we're going to need international AI regulation. So how are we going to go about in these 50 minutes that we have? Each of us could easily fill those 50 minutes, and each of you in the audience too. And so what I suspect we could do is we have very short intro statements from each of us. Then we're going to have a little bit of a conversation between the panelists, and then we want to hear from you, from the audience, both on in person and on Zoom. Welcome to everybody around the world. And I'm just going to say that it's an extreme pleasure for me to be here because we've just, together with my co-lead, Sarah Hammer. Sarah, where are you? She's here. We've just, from Wharton, we've just launched the International Expert Consortium for the Regulation, Economics, and Computer Science of AI that is generously funded by the Dieter Schwartz Foundation. And we have assembled this group to facilitate fact-based policy advice and to address some of the large questions that AI is bringing to this planet. Because let's face it, we have a world in crisis mode, but at the same time, we're seeing AI accelerations happening around the world with a lot of promise, but of course also certain risks. And it is our perspective that we want to try and disentangle those questions in collaboration with some of the greatest minds in the AI space. So right now, there is a momentum, I believe, around AI regulation, for better or worse. And we could take a step back and just ask very briefly, why do we need this kind of regulation? Why do we need international regulation in the first place? And this is something we can very seriously debate. I do think that we need some kind of minimum regulation. And I personally also think that there is a need for an international collaboration on this. Why this? Well, on the one hand, of course, oftentimes you get the answer that, and that's a straightforward answer, kind of we need international, we need protection of individuals in society from some of the risks and so on. That's not wrong per se, but there's quite a bit to be said also for self-regulation, regulated self-regulation in this context, I think. But what we do need, I think, is minimum standards so that, on the one hand, we don't have a race to the bottom when it comes to regulation. And make no mistake, at the moment, governments around the world, I think, are in a fierce competition because we have an economic downturn everywhere. And one of the areas that is still working next to defense industry is just AI, And so obviously governments are trying to lure investments to their countries. And there is, I think, a real race underway for offering competitive legal and regulatory frameworks for companies to come to certain places and invest. And that is important. And it's even more important, perhaps, to look at harmonizing these safe harbors where companies can operate with some kind of safety and innovate, to harmonize them to the best extent possible across multiple jurisdictions. Because if you have one large model, you don't want to retrain that model just because now you're shifting from the US to the EU, right? So that would be really bad also from a sustainability perspective. And that's, I think, the deeper reason why we need international collaboration, to make sure that we can roll out these models in a smart and sustainable way, in a safe way, across the globe. Now, how could such an international framework look like? I think there are at least three major challenges or things in which international collaboration can be helpful. So the first one is to collect evidence and research, particularly on AI safety and industry best practices. And you could think about having some kind of a kind of repository of people coming together, leading experts, a bit like the IPCC, that collects and publishes research on AI safety. This is something that has been thought about already, but that's certainly, I think, not the most important part because we have international AI conference and stuff, and it's not so clear that we need another repository. What I think is more important is the second point, that is kind of the enforcement mechanism where regulators from around the world come together to focus on certain priorities, because we do see that there is the same questions being asked all over the place. The FTC has similar questions to the European Data Protection Board. Japanese regulators have similar concerns, and South African ones too. So this is something where we see in other areas, for example, in antitrust law, that regulators are coming together, discussing these questions to have some alignment across the planet, and not necessarily the planet, but on a broader international scale. I think this could be really helpful also for companies, so that we have clear enforcement objectives and collaboration on this. And third, of course, a global compact for AI. And is this something we can aspire to? Is this something that makes sense? Is this something that could, have a basis, for example, in technical standards that are being developed? I would be slightly optimistic about the benefits of this, but whether this is feasible is a real question. So now I would like to give the floor to my outstanding colleagues and co-panelists here, to think about these questions a little bit more, about the formats that we have in place already, the frameworks that we can think of, and the reasons behind them for having this kind of international regulatory convergence or not. Miriam, would you perhaps like to start? As I said, Miriam, she has basically two roles, and she'll say a little bit more about this. She's not only the president and CEO of EqualAI, which is a nonprofit, looking into AI biases, equality, and alignment, but also is in a very distinguished function, the chair of the National AI Advisory Committee to the US President. So Miriam, it's a great pleasure to have you here. And would you like to start with some remarks?
Thank you, Philip. Thank you for teeing it up so well. Really excited to hear what my panelists have to say. To make sure that it's clear the different hats I'm wearing, they're probably names you may not be familiar with. EqualAI launched 5.5 years ago, pretty much here actually at Davos. And we work with companies and policymakers to ensure that AI, as Philip said, is safe, is responsible, is inclusive. We work with wonderful leading companies who care to lead on responsible AI, some of them here, Pepsi, Verizon, and others, and policymakers, because in answering your provocative question, is regulation necessary? At the end of the day, it's happening just like AI is happening, and so it's important that we're clear and consistent. It's important that if it's going to be regulated, it happens now. 5 years from now is too late. AI is the future's here. If people are building and deploying and don't know the rules of the road, but yet we're going to hold them liable in a few years, that's really problematic. And so that's my day job. The other job with the National AI Advisory Committee is 26 experts who are appointed to advise the President and the White House on AI policy. And Krishnan is one of our esteemed members. We have both broad and narrow mandate. Broad AI policy, narrow in that we're advising the President and the White House. So our lens is really focused on executive branch action, which fortunately there's been a lot of, and we've been really fortunate to participate in some of the important work happening there, as well as while they've kept the framework broad, they've also mentioned a few specific areas for us to weigh in on: workforce, competitiveness, research and development, international collaboration. And so we've organized ourselves in working groups accordingly. And Krishnan, I might add, is the chair of our AI Futures opportunity and I'm forgetting
That's
the word.
That's good enough. AI Futures.
AI Futures, which we call it affectionately. It is very important. It is. What is the future? And how do we make sure we're prepared? So we've been very focused for a year and a half, which we've been in existence, on what does the executive branch need to do immediately. We operated in a traditional format in our first year, planning a report that is now public on ai.gov/NIAC. And you'll see in there the actions that we thought were most imperative that the federal executive branch, the White House, take immediately. You'll find 14 objectives that we are outlined in 24 action items, ranging from the NARE, the National AI Research Resource, which we thought needed to be funded and operational immediately. Philipp mentioned our interest in the NIST framework. There are two areas we leaned in on the NIST framework. As you may be familiar, NIST is a small but mighty organization out of our Department of Commerce that helps establish standards across the board, from electricity currents until now in cybersecurity and privacy, now AI. They released the AI risk management framework by congressional mandate last January, and it's really been moved the needle in really important ways, both in substance and the framework that it's provided for conversation, as well as the model it sets. They deeply corresponded with and involved hundreds of organizations, various governments, nonprofits, industry, to make sure that whatever they put out had the buy-in and participation across all of those organizations. They also made sure that whatever they put out was not purely industry focused. They saw that we all have a role to play at various stages. And so they took into account, what does a nonprofit actor need to know? What does someone need to know when they're licensing and deploying versus building? They mapped it out into 4 functions. There's map, govern, measure, and manage. And it's both wide in its application across the board from any AI user at any point of the spectrum, and very targeted. They go very deep on each specific area. It's a lot to take in, and so they created a playbook, which you can also find online, to help you understand how best to fit in, how to answer the questions, how to fit your use of AI into this tremendous document that they put together. At EqualAI, we put also an impact assessment tool on our website based on the NIST framework to help incorporate further adoption with one of the best practices. So in our report, in our first year, we leaned into the NIST framework in 2 ways. First of all, it was our first action item, talking about making it more broad scale in the government adoption of this very important framework. We also had a separate place later on talking about how we could use this in international collaboration. It's already being used in several different ways. The people who created the framework are involved in our TTC negotiations and several other international organizations that are leading the forefront on AI regulation, we wanted to endorse that we think this is the best path because of how multi-stakeholder, inclusive, and effective their framework is. The other thing that we have been a part of is a lot of the action items you'll note and objectives were incorporated in the recent White House executive order on AI that came out in October. And that, I think, again, another very exciting development. I'm excited to hear what you all think about that. But, we've heard from the EU on their perspective, and I think that was the trigger for so many to get in the ring and make sure that if they're going to speak, they better speak up fast. And we saw the White House speak as comprehensively in the most, I think, extensive EO in the history of the U.S. 150 executive order, I shouldn't be using acronyms, 150 action items across 50 agencies with tasks ranging from research on labor and workforce to setting up a new committee within the White House to make sure there's senior leadership that is nimble and effective. So I will stop there so I can hear my panelists, but looking forward to our conversation.
Thanks so much, Miriam, for this great tour de force and kind of a mountaintop perspective, despite the fact that we're on the valley stage, on the, on the different fields of AI regulation or incipient AI regulation in the US and the links to the international context. We do have another regulation on the file, and that is, of course, the AI Act that some of you might have heard about. And as I mentioned before, a driving force behind many of the, I think, quite reasonable provisions, but that's up for debate, in that AI Act is Kai. So Kai, can you fill us in on the latest inside chit-chat talk on where do the negotiations stand? And I can already see people starting betting on their smartphone. But so perhaps also with a certain view, I assume most people are vaguely familiar with the general architecture of the AI, but maybe just with a little bit of a focus on foundation models. And there's been a little bit of controversy, of course, with Germany, France, and Italy opposing certain types of regulation. It's a little bit unclear where this is headed at the moment. It'd be great if you could update us on the latest events here, and also perhaps at the end your perspective, how that links to some other international perspectives.
Yeah, no, gladly. So first of all, thank you very much for inviting me. What I will do, maybe you hear a few commission people talking in the next days or weeks that are probably much more positive than what you hear now from me, because I will give you a rather realistic view from my side, which is not so good. But let me start maybe from the beginning. As Philipp was underlining, where are we right now? We are at the very end of the negotiations. So on Wednesday, there is another technical meeting, and on Thursday, there is probably a final technical meeting. In those, we are now just working on the recitals, trying to really finalize the text. And then apparently, until now, I myself do not have the final 4-column document. Hopefully, we will get it on Friday or on Monday. And I'm pretty sure shortly afterwards, there's a big leak at Politico or wherever, not from me, but from probably the delegations, the member states. They are more free in bringing out those documents, and then you can all read it. I truly hope that the text is until then highly improved, because right now it's not that good. I will come later to it. This maybe just to conclude the first part of my short intro. The next timeline after the negotiations are over, or the next steps, are, as you know, the votes, which will take place in February, March and April probably. So after April, hopefully it will be then adopted in the council by the member states and by the parliamentarians. Then we have lawyer linguists, legal service going through the translations in the 24 member state languages and other languages. And then in May or June, it should be published in the European official journal and become law. Then we have different transition periods, 6 months for prohibitions, meaning that prohibitions will already apply by the end of the year. Then 12 months for general purpose AI models, the new name now for foundation models, which mean next summer, Sandro and others will be probably being affected by it. And then for Annex 2, the sectorial legislation will have 36 months transition period and all the rest 24 months. Meaning summer 26, the majority of the AI Act would apply to developers and users or deployers, like they are called now. With that, maybe the next steps are like that. What is maybe coming on top, as you know, Sensenelec is now working on standards. The Commission is starting with guidelines. The national competent authorities and the Commission are trying to build up their enforcement bodies. More on that shortly later. How would be my assessment? I said if here a Commission person would sit, probably it would be very positive. Axel and myself, we are really torn between. As Philipp was saying, we were heavily involved. I spent now, I don't know, 4 years of my life really very, very closely to this act, and we had to talk in the bus over the AI Act. I was really disappointed after the result, because I truly believe that it was a big chance to create a tremendously good working future-proof digital law. But in the end, we will not have it. What is good, maybe to start with that, in the negotiations, we made a lot of improvements, maybe on one topic that was mentioned already partially. We aligned internationally on a lot of points, like the most famous one, the OECD AI definition, where Karine Persé and others and us, we are constantly talking with each other in order to manage what happened at the end, that there's an update in the OECD, and rightly afterwards in the trilogue we are taking over the definition, which will also help with our NIST friends and so on. We also managed to relieve the developers of high-risk AI systems a little bit from the unclarity what those high-risk obligations in practice really mean for them. Because it was not really clear if you now, with a high-risk AI system in the employment sector, really need to literally fulfill everything that is standing on data governance, bias, and so on in Article 10. There we gave a lot of more flexibility. We said you need to take into account the context of use, so the individual use case, and so on, and so on. And of course, it was mentioned already, we also had a huge focus on foundation models and even more on AI value chain. And this was one of those topics, as you, or many of you know, many of you supported me there also with a lot of really good feedback. I think it was really a big chance to change a little bit the dynamics in the digital economy, to help especially smaller market players with more information in order to get compliant and so on. And there, in Article 28, I think we still managed quite a bit. In the future, there will be hopefully more accelerated information flowing around along the value chain. When it comes to foundation models, wow. Yes, I was maybe the author at the very beginning, or I was, because Axel and I were bringing this topic in the parliament, and then it was also our text, which was the basis for Article 28b. But let's say with the end of the final version of Article 28b, I had already my problems, and I definitely have my problems with the current text that is being proposed. With that, I'm now going from the positive sides of the AI Act to the more negative side. One of the biggest issues that we had was maybe also depending or correlated to the upcoming EU elections. The AI Act, as many of you know, is really one of those prime examples of laws in this legislative term. So von der Leyen, but also a lot of parliamentarians really wanted to have the AI Act as one of the big success stories for the new European election. The side effect was that in the last months there was such a time pressure to close it as soon as possible, no matter what, that what I heard a lot of time was, yeah, quality doesn't matter, we just need to get it done because we need to have an AI Act. It's true that you can also later on improve in law, but the ones that are close to lawmaking know that it's not so easy, and often really bad ideas that once made it in a law are staying in for a long time. And this is now a little bit the problem. The speed led to a situation that the text, in my opinion, is creating a lot of legal uncertainty. So for example, on foundation models, if I would be now a representative of a certain company or certain companies, I would already know what I need to attack in order to win a court case, because the procedure doesn't make any sense. Certain rights for the defendant are missing. Certain procedures that are or that need always to be there for notification procedures and so on were not taken into account. The criteria and also the obligations, again, conceptually, I stand fully behind it, but what is now in the text, again, doesn't make sense. How was the number of floating points, flops created, 10 to 25? I can tell you, I was in the room. I was arguing very strongly against it. We had 10 to 26 from the council, 10 to 24 from the parliament. Therefore, the geniuses said, okay, let's make 25. What is the reason? What is the evidence behind this? No one knows. No? And this is, again, this is a little bit the downside of this type of policy making or law making that we saw in this AI Act. A lot of, in my opinion, really, really good ideas, but implementing it or written down in an extremely bad way that will fall on our feet, like we say in German. So I said now a little bit to the procedures on foundation models. I will close soon. But the same now also, then my rant is over. The same,
Speed matters, not quality.
Exactly. The same applies also to enforcement and governance. We have there the situation that there's a lot of laws, of course, already existing. We have legal overlaps still with the AI Act and sectorial legislation, GDPR, and so on. We fixed already a lot, but there's still. But now in the enforcement area, we have a lot of agency, the European Central Bank, even an institution, which has already competences on AI, which will overlap now with the competences of the AI office. Then we have an AI board, then we have national competent authorities on AI, and it's not really clear how this is working out. And therefore, again, my final negative point, and more we can then later also elaborate on, unfortunately, despite all those good ideas that still made it in the AI Act, what the AI Act really wanted to achieve. The AI Act, this we criticized from the beginning, was never about promoting innovation, was never about bringing together the brightest AI developers, improve research, blah, blah, blah. This is never AI Act. The AI Act had one target: to increase legal certainty, to build up a legal framework that gives developers, but also civil society, kind of legal certainty when they are confronted with this AI system. And now, if we look on the AI Act, I just really picked a few points that created legal uncertainty. In our reading, it's kind of the opposite. We are creating a legal framework that is creating huge uncertainty. And again, if you are talking now with OpenAI, with Siemens, with whoever, they will tell you that, but the same applies for civil society. probably if they are trying to go against certain violations of laws, the companies that violated those things that were violated will probably often find a loophole. So for whoever you talk to probably will be affected rather negatively by the AI and by the legal uncertainty that it brings. And in the end, my biggest fear is that it's creating a kind of compliance monster that most of the companies, European companies, can only comply with if they are buying expensive certificates and third-party auditing from Big Four accounting firms and international law firms. And this, again, would be exactly the opposite what we wanted to achieve with it. And really the final sentence, my only hope is that the industry, and there I think we see some positive aspects, but also civil society, this time they are not in Europe, they are not waiting for the legislator, they are not waiting for the state to become active. I look already a little bit to Till and also to others, Applied AI, but also a lot of other players that are now proactively already working on compliance mechanism and so on. And this is basically now, I think, based on this not so good written law, the only chance that we have in Europe, that industry is filling those gaps and is immediately addressing this legal uncertainty that I was talking about. Sorry for being lengthy, and now I'm done.
Thanks, Kai, for these encouraging thoughts from Brussels. It's certainly great for me as a lawyer to learn there's more work to be done, and I'm really happy about that. But no, it's a serious concern, I think, both at a national or regional and at an international panel, because of course, all the AI companies that want to operate in Europe will be under this sword. And there are great initiatives, however, already that are taking shape, as you mentioned, bottom-up initiatives, let's say, from industry, but also top-down initiatives from NIST and others that try to connect some of those vague terms, and to a certain extent, legal terms will always be vague, but connecting them with practice. I can see Sebastian Heinzleben over there, who's actually working on Sensenelec, heading the committee, who's doing great work in advancing this, hopefully at full speed, speed and quality there, to match to bring out the technical standards in time for the AI Act to apply. But now, Krishnan, do you want to comment a little bit more on perhaps the way in which you can connect this legal conundrum, regulatory, I'm not going to say monster, but at least challenge, with the boots on the ground, let's say.
All right. Thank you, Philipp, and thanks for your leadership, and along with Sarah, and actually convening us together. It's an honor to be on this panel. It's great to hear the framing remarks from Miriam and the positive and the negative remarks from Kai. So what I thought I might do is offer just a couple of framing ideas from recent participation in convenings on AI in India and in Singapore, and then really pivot to the focus on how do you go from policy to practice, and what are the issues that arise in actually thinking about this, not just as a horizontal kinds of regulation or due diligence that needs to be done, but also what exists vertically in key sectors. So on the higher level framing side, it's important to draw the distinction between developers and deployers. And in many countries, the question that they're asking themselves, just on account of the way the market structure for, in particular for foundation models is arising, is there are very few countries that are developer countries. The vast majority of them are deployer countries. So the question is, if I'm a deployer country, what are the sets of issues that I need to be concerned about to ensure, for instance, that even pre-deployment, what do I need to ensure? But equally well, post-deployment, if a vulnerability is found, what kinds of commitments and obligations does the developer have to resolve the vulnerability? So when I speak about going from policy to practice, I'll spend a bit of time talking about pre-deployment and post-deployment, and how there are parallels perhaps from information security that can potentially be used in the context of AI. So the first issue to resolve, I think, is developer versus deployer. The second, I guess, is horizontal versus vertical. Speaking from the US, which I know a little bit more about than the EU setting, for instance, the Fair Credit Reporting Act, the Equal Employment Opportunity Commission, there are particular sets of existing regulation which can apply in those settings where AI is just a means to an end. There is no regulating of the AI. And here it's important to think about not AI and model components, but the AI system. So what matters is the system, not necessarily just the components themselves. And so oftentimes when we talk about AI regulation, there is an over-emphasis or an over-indexing on thinking about the model components, which are important, but oftentimes almost any deployment of AI involves human components, AI components, and it's the system that we are concerned about because it's a system that produces outcomes that can potentially cause harm as well as can cause the benefit. So with this AI system point of view in mind, then the question is, and picking up on what Miriam talked about in the context of the risk management framework, the AI risk management framework, there's a real opportunity to create what are called AI RMF profiles. So risk management framework has a particular mechanism called a profile that allows for, in particular use cases, to determine what risk thresholds are acceptable. So for instance, in the context of hiring, what kind of false positives and false negatives are acceptable? What error rates, if you will, are acceptable? Not just of the model component, but of the system as a whole. And who bears the cost of these errors? This goes back to the impact assessment tool that Miriam alluded to. So I think the question of figuring out what is acceptable is going to be very different based on use case. Hiring is very different from healthcare, is very different from autonomous vehicles. So these profiles offer potentially a mechanism, but what remains unspecified and unclear, which can only be done, in my view, via public-private partnership, is this idea of coming up with processes by which we can agree on what thresholds are acceptable, by which I mean the error rates that are acceptable for deployment in particular settings. The profiles are the mechanism to do so, but what the rates are and what should be acceptable is something that I think is work to be done. Today, in fact, after our meeting here today, I'm meeting with a group of Global 100 CEOs, and one of their biggest concerns is this issue of uncertainty related to the lack of standard ways, if you will, of having a process by which we can come up with these error rates. Here, I think it's useful to think about a metaphor. So, for instance, if you look at financial statements, in the US, there's this generally accepted accounting principle, so-called GAAP principles. So you have the auditing firms auditing a given set of financial statements of firms that are traded to determine if they are GAAP compliant. So what is the gap for AI in particular use cases would be potentially a good metaphor for us to think about, and to have processes like GAAP, which by the way was public-private, to actually come up with what are acceptable thresholds. So the profiles are a mechanism, but coming up with processes is an important issue. So I'd say that's one particular topic I'd like to focus on in the context of pre-deployment, because prior to the deployment of an AI system, if you had a profile with acceptable error rates, then you could create the testing harnesses, the suites of test data on which you could actually determine if the model and the system is compliant with the acceptable error rates and thresholds. Here it's important, again, to keep in mind, drawing on an analogy from software engineering, that in some cases, as you know, with the existing large foundation models from the OpenAIs and the Googles, all you get is API access. So you have black box testing versus white box testing versus gray box testing. So white box testing is where you have complete access to everything. Currently, other than for the 10 to the 26 flops example that Kai gave, where there's either national security or other such considerations, where, for instance, the exec order requires complete disclosure, we don't have complete white box testing of models. For the most part, all you have to do is work with black box and API-based access to determine is the model component functioning adequately to the level where we are able to come up with the risk thresholds that are deemed acceptable in the domain of application. So this is a deeper dive than perhaps I have enough time to get into, but let me pause there on the pre-deployment front. I want to switch now to post-deployment, because irrespective of what due diligence you do pre-deployment, it's inevitable that you're going to see vulnerabilities, errors arise post-deployment. So from work of colleagues at Carnegie Mellon, they were able to break the guardrails. So if you ask it to build a bomb, it'll politely say, no, it won't help you. But if you say build a bomb and follow it up with a series of suffixes, it's called a suffix attack, you can actually break the guardrail. And you can machine learn the prompt that will actually break the guardrail. So I think these questions of how these errors that we discover post-deployment are to be resolved requires an infrastructure, an agency. So in information security, we have something called the Computer Emergency Response Team. These are called CERTs. So you have voluntary disclosure of errors, bugs, etc. The CERT does forensic analysis of the vulnerability, determines how risky it is, and lets the developers know so that the developers can fix it, so that you have a closed-loop system that leads to a more safer ecosystem. The US has just stood up an AI CERT for the Department of Defense. And I suspect that just like with information security, you're going to see a network of CERTs, AI CERTs, emerge in different geographies and jurisdictions, with the expectation that there are going to be these kinds of errors and vulnerabilities, some of which are only business relevant, but then others are more malicious and may have national security and international security implications that need to be shared and resolved. So let me conclude by saying this is still murky waters. I think it's still taking shape, that there are particular sectoral kinds of existing regulation that are potentially applicable to address use cases. The AI RMF offers a potential mechanism where profiles to actually make this concrete and potentially become a standard way of disseminating these standards. It's important not just to focus on pre-deployment, but also on post-deployment, and that there's a need for maybe drawing a parallel with information security for a worldwide network to deal with post-deployment concerns. So let me thank you all for your attention and turn this back over to Philipp.
Thanks, Krishnan. Those really wonderful remarks, and I think that particularly noting again that there are implications for testing between white and black box models is really important and will inform our understanding of how we frame the trade-off between open source and closed models. We have in the room, of course, people from different fronts here. We have OpenAI, we have Björn Ommer, who actually engineered at his chair Stable Diffusion, which obviously is an open source model. And so that would be a different conversation to have, very worthwhile one. But now let us maybe jump with Rasmus into some of the perspectives, because we're in Davos after all, not to talk only about research, but also about practice a little bit. What do you think, where's this headed? So what are the major points for businesses? Is it mainly the AI Act, or is it some other legislations, product liability, other things that are also, or should be on the minds of companies, and how do you view this emerging regulatory space?
Sure. I mean, already lots of great ideas here in the discussion, so happy to continue there. Kai, I really like the entrepreneurial dynamic on the EU policy level, but there's also some irony. I think like if we would probably fill out our documentation for our AI models in the same like rushed way, I'm not sure if people would be happy. So, but yeah, look, I mean, we as entrepreneurs, we have to work with what it is. You know, the regulation is there, so I think there's no point in discussing about do we need regulation or not. I think we do need regulation. I think what's really important from an application perspective when you're actually building AI models and want to deploy them in practice is clarity as much as possible, and also speed. Because ultimately, I mean, when you build a company or build an application, you have lots of stakeholders you have to keep happy. Like there's your investors, they're asking about EU AI Act, does it affect you? There's like employees that are concerned about, is that what we are doing? Is that actually legally allowed? And then the worst or the most important, the customers. And what we've seen with GDPR is that we spend so much money on lawyers. I mean, they in the end are, I guess, happy, but on like extra certification documentations, really just like hundreds of pages of, documents that prove that what we're doing is like compliant with all the laws. Nobody ever reads these reports. It's just cover your ass ultimately for somebody at the customer. But it creates just extra cost, extra friction. And we need to reduce that as much as possible. So what I would really urge is now, when things get concrete, because it's very easy to talk about these topics very high level, but when it's about like being very concrete on what are the actual standards, numbers, concrete documentation requirements, that there's as much clarity as possible and also examples. And also to that extent that when we fill this out as a company, we firstly don't need to pay a lot of consultants and leakage on the way. And secondly, we can point to some also like more public resources. And we say, look, like what we've done here is compliant with the law, and you as a customer can trust us, because the worst thing that can happen is that this slows down our sales cycles, and that's especially bad and harmful for like startups and SMEs. It's not a big problem when you're a big tech companies. You just pay another 100 lawyers. They will figure it out. They will get you all the certifications, all the numbers, everything, and it will look fancy. So I think that's something I think we need to be really careful about, because otherwise we will just kill or at least slow down and harm like a lot of the AI industry. And we also need to make sure that we change the narrative a bit. I think everybody saw the memes that Europe only leads on regulation. And I mean, I was hoping somebody on the EU policy level would also see this, because I think there would have been a great opportunity when the UI Act came out and Europe was and is really leading on the regulation side. I mean, we are to say, look, but we also are leading on the technology and research side. Let's put some money to research institutions, to startups, doesn't matter where, but also change the narrative and say, look, like, yes, we regulate, but also we want to make sure that in the next 5 years and 10 years and beyond, we are also building here in Europe. I think that would be really encouraging, and even building in high-risk applications. I mean, these are the high-reward applications. We don't want people building games or, I don't know, stuff in advertising. We want people to build in healthcare and mobility and all these really critical areas where, yes, there's a lot of things that go wrong. That's why we need regulation, but that's also where the real opportunities are. And I think that's a lot of narrative, and also a lot where kind of, I guess, the policy level can help kind of shifting the narrative. And that's something I would encourage leaders there in the upcoming months to really encourage people building. The other thing is, I think we need to think about this globally, and that's why, I mean, that's also one of the reasons why we started the AI House. I mean, we can have our discussions in Berlin, you can have your discussions in DC, that's all nice, but ultimately, AI has become a very global topic. I mean, we're all using maybe foundation models from one continent, building applications in another continent and selling to a third continent. People are working globally, organizations become more global with remote work, and so also for AI to work really, we need to make sure we have global standards, global regulation as much as possible. And so I would encourage also everyone from the national initiatives or European, US initiatives to kind of work as close as possible together. So that's very easy for a company to kind of move to another continent, to also ship products there, and also make sure there's not regulatory arbitrage possible. I mean, I heard there's already now, with the copyright law, opportunities to potentially, I don't know, go to Japan, train there, sell the model somewhere else. Like we've seen that on the tax evasion side. I don't think we want to see that on the AI regulation side. So let's try to make as much global standards as possible. And then, kind of last point, I think what's really important is the regulation. I think from a startup perspective, it's fine. We will deal with it, but kind of the bigger topics I think that we will also see coming up this year are two. One is liability. So I mean, there's a new product liability directive. Was also sneaked in a couple of weeks ago. The topic of like who is ultimately liable when things go wrong. Because we need to be clear, like AI will make mistakes, human makes mistakes. Let's also not have double standards, by the way, when we say what are the levels AI need to reach. Like we humans are so terrible at so many things. So let's have like reasonable standards there. But then also let's make sure and figure out who is liable. And obviously through the AI Act, we have now some standards about like from the model perspective, from the people building the applications, from the user, like the data basically flows and people have some transparency. but that is also somewhat related to the liability topic of like who in the end is liable. Because if you don't know what data this was trained on, what kind of model it is, it's also hard when you are then liable for something you can't deal with. And that's also something we've seen quite some tension also in the AI community that before kind of everybody in the AI community was pushing together, but now there's some people building the foundation models, there's some building the applications, and they don't always have the same incentives. And both don't want to fully be liable, but also if they're not liable at all, maybe nobody will use their products. So it probably has to be some balanced act. But I think that's something that's super important to figure out as we're building these high-risk applications, that there is some standards and guidelines for this to happen. And then lastly, I mean, another obviously big open topic also with the New York Times lawsuit is everything around like copyright and also having more clarity on that because we need to train on large amounts of data. Some people have created the data. They need to somewhat be incentivized, but we need to find a mechanism in that also on a global basis. So yeah, lots of things to do, but ultimately, yeah, I hope we build more meaningful AI applications and the EqualAI Act and other initiatives are not hindering this too much.
Thanks. Those great points. Actually, I'm going to hold back with my own opinion. I just published a paper actually yesterday with Luciano Floridi on many of these legal aspects, covering a little bit copyright and product liability and other things. What I want to highlight just very briefly is this change of narrative. I think it is up to now a huge missed opportunity. Actually, my initial reaction when the AI Act deal was after 38 whatever hours was put forward was also quite not overly optimistic, let's say, and a bit negative, because I think we need to match this regulatory momentum really with a massive public spending momentum. The US is committing a lot of money, the UK is, Norway is a small nation, but what's the EU doing? Well, we're now giving access to some SMEs to supercomputers. Oh, that's fantastic. So I know that we need to draw this to a close in a few minutes, but I think really committing in the number of billions of euros to a fund that can then invest strategically in research, in startups, in meaningful things to push AI forward and to say, in Europe, we're not only here for regulation, we also want to have this stuff, because otherwise people are going to be dying here. Like my sister works in a hospital, and they're really not coping, and it's a fantastic hospital in Germany. So, and so seriously, I mean, there's lots of missed opportunities and lots of risks from not using AI, and this is something we should have on the table as well. Okay, so we have about 2 to 3 more minutes. So maybe what we're going to do is, because we've already talked a lot, can we just have 1 or 2 questions from the audience, and then we're going to have a final round of, maybe you have some question comment kind of style. Keep it short, please, and then we need to evacuate the dance floor for the next session. Okay, we'll start to the left, Björn, Till, and here.
We could bundle questions.
Yeah, we're going to bundle. We are going to have all the questions, and then we're going to have a final round to answer them. Okay, Björn, do you want to have the mic here?
Thanks, everyone, for this wonderful panel. I understand that after a long time, Trilog eventually embraced that there's not good algorithms or bad algorithms, but bad applications, they're potentially critical. At the same time, I like what you summarized, that there are high opportunity applications, which typically go together with a certain risk, and I guess the elephant in the room are foundation models. Now, towards the end of all this discussion, it was also embraced that open source might be a good thing to have because of lots of opportunities for red teaming and the like. As somebody who, with Stable Diffusion, developed an open source model, a question from my end is, where do we stand exactly in this overlap? I know that there are things which are really hard to put together. Where do we stand with foundation models that are, however, open source? Like, where are we on, and with that potentially have some risks, but also some openness. I understand that in the present case, it's these qualify as both, and it still needs to be spelled out. Do you see any opportunities that we will come to a distinct answer in that case, or will it be this so-so thing?
Thanks. We'll just take, Till.
Yes, hello, Till from EqualAI. I have a question to Miriam. We talk a lot about the international regulation. Of course, the US is a big player here. We've seen the Biden executive order, but we also see yesterday Trump in the pre-elections. We have the upcoming elections. And so I was wondering if you have any intuition or insight even about the priorities of a potential Trump administration when it comes to AI regulation. Maybe it's too early to ask, but I would be curious in your take. Thank you.
There will be a wall. Yeah, a big firewall, and they're going to pay for it. Okay, so yeah. Introduce
all
yourself real quick.
for the great comments. Particularly Miriam, I'm a big fan. I like watching your committee sessions online. You chair them very well. I'm Neil Lawrence, University of Cambridge. The question I wanted to ask about, the thing I find most disturbing is the lack of any conversation about the consequences in developing economies, who are the most vulnerable to the changes in information infrastructure we're looking at, are the most vulnerable in terms of existing institutions, the ones that could benefit most from these capabilities and technologies, and for being thought about extremely little in any of these regulations. And what are we going to do about that? Because those are serious consequences by focusing too much on Europe and the United States.
I have one question I can speak from here. So,
Yeah.
Ramayya spoke about risk, which is pre-deployment, post-deployment. There are risks which are input side of risk, what goes into foundational models, and what comes out, which is related to data sovereignty on the input side and liability on the outside. Rasmus, you spoke about, I'll just quickly come back to my question. You spoke about liability allocation, but then this is a collaborative work. Like, there's a value chain being created. How do we do allocation across the value chain? Then you spoke about a lot of things that, a lot of work that consultants would have to do, but maybe AI can do that work for you, so you can save yourself of the consultants. But around all this, what I want to come back is, are we early with the regulation itself, the genesis of the law? Or should we wait with this? Because this is just another technology, right? We've come through technology. We did not have a Metaverse Act. Metaverse was quite big, let's say 2021. That's it. So, yeah, what's the genesis of the act, and are we early or late?
Great. Oh, yeah, please.
Philipp saying from Versus. What we've been seeing about regulation has always been actions post facto, right? So the question is, we're focusing a lot on large language models. How is regulation going to take into account the operations, so smart cities, supply chains, etc.? And how do you regulate things that you don't understand? So the explainability. What's the perspective on that?
Those are a lot of great questions, and I'm getting
hour.
and yeah, I've just been told that we have been granted another hour. That's super kind. Thank you. No, so maybe just really one sentence from everyone, and then we're gonna be out for the next panel. So really, one sentence.
Human brains are also not fully explainable, so I think we need to be realistic. What can be explained and what can be not. But obviously, more is better. And I think like the developing world, super important. That's why ideally we have it globally, and not just in the US and Europe, but like global standards and regulation.
So really quick, I think as part of my Senate testimony as well, this question of product liability on the one hand and transparency on the other. I think we need to solve for that. One thing that didn't come up, which I thought would come up, is this whole issue of content provenance and the C2PA, synth ID, what Stable Diffusion does, with regard to ensuring people are aware of the content that's created as AI content. And given that 2.5 billion people are going to the polls this year, is that something very specific and of an issue that needs to be addressed? So I'll just throw that out there.
Another big point. Yes, thank you.
As we talk about regulation and liability, super important. We've had some significant work we've talked about here. There's so much more going on. But I think two of the key points that were just raised, Philipp talks about opportunity in healthcare, in education. There are so many ways that we need to make sure that we do better with AI. We have this opportunity in this revolution that we're living through right now to do better. How can we make sure that AI is a part of creating that opportunity? And to the point of inclusivity, Nyack had a recommendation that came out this summer talking about emerging economies and needing to make sure they're at the table. It's impacting them. We need their voices included as well.
And I will focus a little bit on stability AI's question. So I think what is good now is that the policy level is disappearing a little bit on the AI Act, and now the experts are taking over again. And due to those points of legal uncertainty that I mentioned, I think actually, of course, it's a huge risk, but for companies, for players on the market, it's also a huge opportunity. at the moment, the Commission cannot really answer the questions that you were posing yourself. No one can. They are relying on feedback from stakeholders and so on. And they also are starting to hire experts and so on. And I think there, you and others have really a huge opportunity to shape where we are heading.
Great, thank you. We are really literally being kicked off stage. Thank you so much for this delightful conversation. Just for one group picture.